Gretsch. I'm the president and CEO of the Queens Chamber of Commerce. Thanks so much for joining us. You know, the last number of months have been very, very heart-wrenching in a lot of different levels and very, very challenging for folks. I have to take my hat off in all sincerity to all the appointed officials that work for the city government, whether they're from Department of Buildings, Department of Veterans Affairs, the FDNY, the NYPD, all of you folks back there that work so hard and for the most part are not acknowledged. I just wanted to say thank you very much for all you do. You are definitely keeping the wheels on our city, as they say, as people try to figure out which way to go. I know it's a very, very tough environment, and what some of the folks from the New York City Department of Consumer Affairs and Worker Protection does is greatly, greatly appreciated. So thank you all very, very much for your hard work. If nobody else has said it, I'm saying it. Thank you very much. We're honored today to have a number of folks from the Commissioner's Office. First Deputy Commissioner Sandra Abeles, and also Claudia Enriquez, and a number of folks for this program about New York City paid sick leave and the laws for businesses, large and small, to adhere to. I just wanted to again welcome you to our program today. We truly appreciate it. I also want to give a shout out to my own team who works tirelessly behind the scene, and Jacqueline Donato, and also our friend Mohammed Amin, who is looking for a second career after the chamber in television production or movie production. He does a fantastic job, and he's a great young man. And the entire team, including Vicky, Ferreira, and everybody else at the Queen's Chamber who works so hard. So again, my thanks to all of you, and we'll turn the program over now to, I guess, Jacqueline's going to say some opening remarks.
Yes, Tom. Thank you. Thank you, Tom, for being here with us today. And good afternoon, everyone. I thank you for participating and for joining us today. My name is Jacqueline Donato, a Strategic Program Manager of the Queens Chamber of Commerce. And here at the Chamber, we want to connect you to free resources ranging from business courses to legal services and guidelines explaining government rules and regulations. That is why we are here today. Let's welcome the First Deputy Commissioner, Sandra Abeles, of the New York City Department of Commerce and Worker Protection for a discussion on the important updates of the pay, safe, and sick leave laws. There has been some significant changes, amendments, and they are coming very soon. Welcome, Sandra, and the floor is all yours.
Thank you so much. So thank you again to Thomas Gretsch for inviting us and for Jacqueline Donato for helping set this up. The Queen's Chamber's efforts to connect us to businesses helps us to get the word out to businesses about important changes, especially to this law, the paid safe and sick leave law. Our commissioner, Commissioner Salas, she understands the value of business education, especially given all the challenges that businesses are facing because of this crisis. So we also want to acknowledge all the businesses that are out there and listening in and doing their best to comply with the law and protect their workers. Now, our agency used to be known as the Department of Consumer Affairs, and now we're officially known as the Department of Consumer and Worker Protection. And so this name change really more fully captures everything that we do. We're a small agency, but we have a large mission. We license businesses and we enforce that activity, and we offer also financial counseling and free tax preparation for New Yorkers through different programs. And most importantly, we protect both consumers and workers through our Office of Labor Policy and Standards. And so at the city level, we offer additional workplace protections, even though the State Department of Labor is still responsible for certain worker protections like minimum wage and overtime. The city offers additional protections to workers through laws like the paid safe and sick leave law. And so here to help us understand some of the most recent changes to the law is our wonderful director, Claudia Enriquez, and we'll have our wonderful member of our outreach team, Miriam Aldana Galdamez, to help provide you with the links and resources that we have on our website. And we've tried to provide many different resources in as many languages as possible. And we're working every day to continue to add translations on there to make it easier for businesses to protect our fellow workers. So take it away, Claudia.
Hi, my name is Claudia Enriquez. I'm the Director of Litigation with the Office of Labor Policy and Standards. So we are a division within the Department of Consumer and Worker Protection. And as Sandra said, the department provides services both to workers and to consumers. And so our division handles the aspects related to worker rights. And in some sense, we're almost like a mini Department of Labor for the city of New York. We have a few laws that we enforce. Probably the best known one is the paid safe and sick leave law, which we are going to talk about today. We also enforce a fair scheduling law called the Fair Work Week law. It applies to fast food and retail workers, and it requires a certain level of predictability in schedules. Workers have to be provided with their schedules a certain amount of time in advance. They have to be, if their schedules change, have to be paid what's called a premium, have to be given estimates of what their schedules are going to be for a period of time. And that's one that we've been spending a lot of time on, particularly in the fast food sector. We also have a Grocery Worker Retention Act. It's not commonly used, but we do have an active case. It's where a grocery store changes ownership. The employers are actually supposed to keep the workers from the former grocery store on for 90 days and give them certain notices. And we also enforce the commuter benefits law. Again, one of our lesser known laws, but it requires certain pre-tax deductions to go towards commuter benefits. So with respect to paid sick leave, this law went into effect April 1st of 2014. We've been enforcing it since then. It's been amended a few times. In 2018, it was amended to include safe leave. So in addition to being able to use paid time off when you're sick or when a family member's sick, workers can also use that time for a valid safe leave purpose. And what that means is if someone's been subject to domestic violence or human trafficking or sexual assault, and they need to seek services, for example, meet with a counselor or file a police report, they can use their same hours that they accrue under the sick leave law. They could use that for safe leave as well. And then most recently it was amended in light of amendments to the state law, or rather a new state sick leave law, just to make sure that our law provided the same protections that are available at the state level. And so I'll talk a little bit about what the requirements were before and then how they're different. Originally, everyone had a right to up to 40 hours of sick leave per calendar year. That was accrued at a rate of 1 hour per 30 hours worked. The framework of that has stayed the same. Previously, if you were an employer that had fewer than 5 employees, that time was not required to be paid, but everyone else was required to be paid. And for employers of domestic workers, they were required to provide time off 2 days a year. And in addition to that, the law requires certain notices to be given out. There's a document that's available on our website called the Notice of Employee Rights. And we've updated now. It's been simplified, much more easier for both workers and employers to read and understand. I think they'll be able to share that link in the chat. And then the employers also have to have written sick leave policies that explains to workers how they can use sick time at that particular workplace. So it's not the same as the Notice of Employee Rights, which generally explain what the rights are, but how to use, what's the employer's actual policy? Like, who do you have to call to let them know you're going to be out? Like, very specific to that workplace. So what's changed in the new law is that now there's no longer a waiting period for workers to use sick time. It used to be 120 days. The worker could start accruing sick time at that same rate, 1 hour per 30 hours worked, the minute they started working, but they couldn't actually use it until they had been there 120 days. And there was also a minimum requirement that they work at least 80 hours in New York City. That requirement has been eliminated. So now they can start accruing and start using sick time right away. For domestic workers, they are now basically covered the same as everyone else. It's not 2 days, it's up to 40 hours. The larger employers now have more, responsibilities, obligations, in that if the employers have 100 or more workers, starting January 1st, they will be required to provide up to 56 hours, which is about 7 business days of paid leave. Everyone else stays the same, except that for those small businesses with fewer than 5 employees, if that business has income of more than $1 million in profit a year, then they also have to provide paid leave. This is to make it consistent with like I said, the state law. The state law provides that the 7 days and that threshold for small businesses. The changes in the law also enhanced our protections related to the confidentiality of witnesses. We've always had, workers have always had the ability to file complaints anonymously, and we only reveal their names if it's required to resolve their complaint. If it's not, we take that very seriously. And we basically, that provision was in our law before, but now it's basically even stronger. We have stronger protections against retaliation, which means that it is not, it has always been against the law to fire a worker for requesting sick time or using sick time or just generally asking about sick time or any of their rights under the law. And it's something that we've had a lot of success in with at court. And now that language is even stronger. So that, is something that we're very excited about. Another, a few other provisions, the employers are now required to make workers' sick leave balances available to them on their pay stubs. That requirement went into effect September 30th. And the employees, if they are required to go to the doctor to get a note, which the employer can ask for if the employee has been out for more than 3 days, and say the doctor charges a fee for the worker to get that note, the employer is required to cover the cost of that fee. Not the doctor's visit, but rather just, if they charge $5, $10 to get the note, then that's something that the employer has to pay for. Right now we're focusing a lot on employer outreach. We recognize these changes came rather abruptly. And so we are using every opportunity we can to educate both employers and the public, and happy to answer any questions people may have.
Thank you, Claudia. The goal of this webinar is to raise awareness about the law with the employers and employees concerns about the law. We have a series of questions for you, and also we invite our participants to raise hands and to write the question on the chat. The first question that we have is, why was the Pay Safe and Sick Leave Law amendment?
Sure. So as I mentioned earlier, the state of New York passed a sick leave law that in some ways was a bit more generous than what the city already had, specifically with respect to the 56 hours for large employers, coverage for employers who had less than 5 employees but had revenues of 1 million or more. So we amended the law to bring it in conformity with the state law. So you can't have if you have two competing laws, since the state supersedes the city, then our law would be struck down. But now our laws are basically offering the same kinds of protections. And so our law is still, it's still good law. So that was the main reason that it was amended. And then there was an opportunity to strengthen certain components of the existing law. For example, as I was saying, the protections against retaliation, there's some clarification as to our agency's enforcement powers are sort of technical, that we, since the law was being amended, we used that opportunity to sort of fix those provisions as well, clarify the position on witness confidentiality, again, make that stronger. But the primary reason was to bring it into conformity with the state law.
Thank you. Can you highlight what are the new obligations for employers under the law?
Right. So as I said earlier, for those larger employers with 100 or more employees, the workers will get up to 56 hours of paid leave. The rate of accrual has not changed. It's 1 hour of sick time accrued for every 30 hours that the employee works. Employers who have less than 5 employees, who were previously only required to provide unpaid time off, if those businesses make more than $1 million a year in profit, then they do have to provide paid leave. There's no longer a waiting period for employees. And for domestic workers, they previously only had 2 days under our law for paid leave. Now they have the same as everyone else, up to 40 hours. And then, as I mentioned, pay stubs, the employers are required to make workers' balances available on pay stubs, reimburse for the cost of any medical documentation, and our retaliation and other enforcement language is changed slightly to make it a little bit stronger. And then not a change in the law, but a change in our materials is that the notice of employee rights, which is available on our website, has been updated so that it reflects the changes in the law, but also we think that the new language is a lot more streamlined and will be a lot more helpful to both employers and workers.
Are all the new resources are available to employers at this moment, or we have to wait until January 1st to start learning about how to comply with pay safe and sick leave law?
So all of our resources are on our website. I believe it's dca.gov/workers, or maybe it's nyc.gov/worker. We can follow up with the exact website. And there's a number of forms on there, including the notice of employee rights. Right now it's in English and Spanish. We do plan to translate it into additional languages. And then there's other tools for employers to use there. There's a frequently asked questions, which has also been updated. And so to the extent that people have more logistical questions or practical questions and maybe want to see some examples of how would this scenario look, that's all in our frequently asked questions as well.
Thank you. We have some questions from the participants. And also I had more questions in our side. Let's see what we have here on the Q&A. From Mrs. De Jesus. She said that you mentioned that employers with more than 100 employees will have to provide 56 hours. What if an employer owns multiple locations and that adds to the more than 100 employees?
So right. So I think we would look at how many are employed by that particular employer, even if it's in more. It doesn't have to be in just one location. But 100 is as long as it's more than 100, it's 56 hours. There's not any requirement of more than 100. Meaning, like if the employer has 500 employees, there's not more hours. Like 56 is the maximum that they're required to provide. That said, we definitely encourage employers to provide more generous policies than what the law requires. So if an employer wants to provide 2 weeks of sick leave, that would be great. If they want to provide sick leave and vacation benefits, we encourage that as well. But they do have to, the only requirement is to meet those minimum requirements of the law. And so for those large employers, it's 56 employees. And it doesn't matter if they're spread out over multiple locations or all in one place.
Thank you. What about the vacation time? Maureen is asking, in the past, you could apply vacation time to sick leave as long as you allow people to take during sick time.
Right. So if an employer offers, for example, a lot of employers offered paid time off or PTO. If that happens and they offer that instead of sick time, in order for them to be in compliance with the law, those that PTO, at least the 40 hours or 56 hours, depending on what the employer is required to provide, has to meet the minimum requirements of our sick leave law. So that means that, for example, oftentimes when employers provide vacation, they require 2 weeks notice. You have to give 2 weeks notice to the employer so that you can take the time off for vacation. For sick leave, it's a lot more flexible. It depends if the use is foreseeable or not foreseeable. If the use is not foreseeable, for example, you wake up in the morning and you're just not feeling well and you can't go to work that day, then you only have to let the employer know as soon as practicable. So as long as the employer allows the worker to use that paid time off in the same manner as they would for sick time, then that's fine. Where it gets tricky is where they call it, paid time off, and they say it can be used for sick time, but then they have all these other requirements that wouldn't be requirements for sick time. So we just have to be really careful. And then the employer should also just make it very clear in their policy, if it does say paid time off, that they can use it for sick leave purposes, and then this is how they can use it, so that there's no confusion. The employer can definitely offer 2 separate banks of time, so they can offer sick leave and vacation. There's currently no legal requirement to offer vacation, so that's totally on, if the employer wants to offer a more generous policy. But if they're trying to use that vacation to meet their requirements under the sick leave law, then at least the 40 or 56 hours have to be available for the employee to use exactly in the same way that they would normal sick time.
Thank you. I have one more question from Nancy. Can you please clarify the deadline for when employers are supposed to distribute the new notice of rights? 30 days from effective date of January 1st?
I believe it was 30 days from when we made it available. So I would encourage you to distribute that as soon as possible. And right now, because the law is new and a lot of people haven't heard of these changes, that is something that we are taking into account in our enforcement. So, if we get a complaint from one worker and it turns out the employer is still using the old form, we're not necessarily going to take a hard line on it if it seems like the employer is really, trying to come into compliance or genuinely thought that they were distributing the right form. Like, we do take all of that into consideration when we do our enforcement and our investigation. So, if you're an employer and you haven't distributed the new notice, it is up on our website now. I would encourage you to hand that out as soon as possible. And you do have to, the law does require you to keep records of distribution. So we encourage you to have the employee sign a form acknowledging that they received the updated notice of employee rights. If you haven't done that yet, again, just go ahead and do it now. And to the extent, if we end up investigating, that is something we would take into account, that you didn't know and now you're doing it once you found out about it.
Yeah, and Jacqueline, I would just add that a lot of what we try to do is encourage businesses to do these best practices, because the more communication that you have with your employees and they know what to expect, and they know what kind of policies and procedures you have in place, the less chance there is for a confusion about what they're entitled to. And so we want our workers to know that they have these rights, and that helps benefit everyone.
Right. And this is a big benefit of having a very clear policy. We get a lot of cases where, for example, the worker takes time off, but it turns out, they told their manager, but they actually were supposed to fill out this form, or, that kind of thing. And if it's not spelled out in the policy, there's not really a way for the employee to know what that procedure is. And so we do encourage employers to have, clear, well, they have to have a policy under our law that's required, but not only just have a policy, but make sure that that policy is clear, that it's readily accessible to employees, that, you have someone available to answer questions, an HR person or a manager that's able to explain particular provisions, so that it's not a mystery. In the end, it's in everyone's best interest when everyone knows what the rules are and how to go about using sick time and all of that.
Thank you, Sandra. Thank you, Claudia. I have so many questions on the chat, but I'm going to keep asking. Um, do you have any thoughts about the interrelation between the state and city laws in particular as to the notice and documentation provisions of the city law?
I'm actually not too familiar with what, if any, documentation the state is requiring, but anyone who's working in New York City would have to provide both. So you still have to provide our notice of employee rights to all workers and meet our policy requirements, meaning the sick leave policy requirements. We are not doing anything that's inconsistent with the state law. So, to the extent that there are requirements in New York City, those are already requirements that you would have to comply with in order to meet the state's requirements. But, to the extent that they have their own notices or that sort of thing, you would have to put up both.
Thank you. One more question from Pedro Goico. He's asking that he said that he's currently front load the 40 hours. After 60 days of work, how will this new affect my policy? As you mentioned, the employee can now get the sick hours as they accrued the hours. I don't.
So I think I understand the question. So under the both the old version of the law and the current version, you can either accrue sick time 1 hour per 30 hours worked, or I didn't actually get into this in the explanation, but you can front load the hours. That means you put the 40 hours available at the beginning of the year, and then the workers can use it. And then the way that it works typically is it's cashed out the extent that the worker doesn't use it, and then they get another 40 hours the following year. Or alternatively, they can accrue 1 hour per 30 hours worked, meaning 1 hour of sick time for every 30 hours that they work, and then that rolls over into the following year. So that part of it doesn't change at all. If you had a front loading policy, you can keep a front loading policy. If you were using accrual, it's the same rate. What is different though is that now workers don't have to have met any minimum requirement of 120 days is what it used to be in order to use the law. So to the extent that there's like a 60-day waiting period, that should be eliminated. And part of it, I think, was related to, the state changes, I think, in part were related to the pandemic. The state sick leave law passed in conjunction with the COVID emergency sick leave law, and they wanted people to be able to use sick time the minute that they were sick and not risk, coming into work sick, getting everyone else infected because they didn't have the ability to take paid time off.
Thank you. And a question from Ursula. If an employee does not have any more sick leave time, what course of action does the employee have to get sick?
So that's a good question. I mean, again, we definitely encourage, the law only requires the employer to provide either 40 or 56 hours of sick time each calendar year. They are not required to provide more than that. There are separate laws related to COVID. There's a state emergency sick leave law, and then there's a federal sick leave law that allow people to take, in the federal one, up to 2 weeks. In the state, it can be 2 weeks. It could also be more depending on, they might be eligible for disability or paid family leave benefits. So, if the worker qualifies for more leave based on that, then those laws would apply. But under our law, assuming it's just normal non-COVID sick time, the employer is not required to provide more than 40 or 56 hours. However, we do encourage obviously more generous policies than what the law requires. And so, to the extent that, the worker or the employer is able to provide more sick time, that sick time would not need to be paid. There is another law that we enforce called the temporary schedule change law. It's I think it's only ever come up once, but it is a law that requires or allows a worker to change their schedule at least 2 times a year based on it's called a qualifying personal event. So it can be actually anything related to safe or sick time, or it can be something else. For example, if they have a court date or if they need to apply for public benefits. So It may be that if the worker has exhausted their sick time, they might be able to get a schedule change, a temporary schedule change under that law. Or again, if the sick leave is related to COVID, they might be eligible for separate COVID benefits. And the COVID emergency sick leave is totally separate from our New York City paid sick leave. So they shouldn't, they shouldn't lose the money or the time that they've accrued under the New York City law. If they have COVID, they should get their benefits either through the United States Department of Labor or the New York Department of Labor.
Thank you. There is another question about why the city law requires the business to state the balance of use and accrued sick leave on each pay stub. The state does not require that.
So this is to help workers, both workers and employers, stay informed. A lot of workers don't know whether an employer even offers sick time. They don't know how they accrue it. They don't know whether they have sick time available to use, and they don't know whether, how much, if they've used it, how much they have left. So it avoids the scenario that was in the previous question. Maybe someone's used up all their time and they're asking for more time off. Maybe they thought they had more time. So this is just a way to get information out there, both to employers and to workers, so that everyone's on the same page as to how much time the worker has, how much time they've used up, and how much time they have available if they need it for the future.
Thank you. Frank is asking if someone in the office claims they were exposed to someone who tested positive COVID-19, can we require that they go to be tested immediately?
So this is a good question. Also, it's something that hasn't really been addressed in the law. I think that if it's not retaliatory in nature, there's no prohibition on it. So, for example, if it's not done just to punish someone because they took sick leave, but rather because there's a legitimate concern that this person might have COVID, and you don't want it to spread in the workplace, I think that that's probably fine. We are seeing those cases, and that is kind of uncharted territory. And a worker can use our New York City sick leave time to go get a COVID test. And for the days that they're waiting for the results, if they don't feel that they can come back to the office or should not come back to or the workplace, they can use our sick leave time. But once if they get that positive test, they should definitely apply for the benefits through the state or through the federal government. Also, if they have, even if they don't get a positive test, but they've been ordered to quarantine either by a doctor or by someone at Test and Trace, they can use the state or the federal benefits, and they don't have to tap into their New York City benefits. But if it's sort of like in a sort of a gray area where, they maybe just are going to get a test or they just need a couple hours off, they can definitely use our sick leave law. And again, I don't think the requirement for people to get tested is necessarily, it's not addressed in the law. And I think it would have to be on a case-by-case basis in terms of how it's applied. If it's applied to punish people for taking time off, I think we would potentially see that as retaliation. If it's based on, genuinely we think this person might have come in contact with someone or might be a risk to the workplace, and then that would probably be fine. But again, it would be on a case-by-case basis.
And there, I would also again point to the New York City Department of Health and Mental Hygiene website, because they're constantly updating their FAQs for employers about the Test and Trace program and about some best practices. And so it's a great resource. It's getting updated, like I said, on a constant basis, and as well as many translations. So that's a good resource for employers to have.
And I believe that Miriam Aldana is also from your agency. She's also posting a lot of forms and links into the chat. And for the participants that are asking if we are recording this presentation, of course, it's so important, it's so valid, it's so timely. We are. And what we do is we record it and we post it in our YouTube channel at the Queen's Chamber of Commerce, and I will post the link to our YouTube channel, where you can follow up and repeat and share this information with your colleagues. It's so important. I have more questions here. How sick pay is calculated for commission-based employees?
So that is something that's in our rule. I don't have the formula in front of me at this moment. It's something we can follow up, but it is addressed in our paid sick leave rules. And if you actually go to our website, it has a link where you can download the law and rules packet. And if you give me 1 second, I can let you know the number of the rule. But yeah, it is something that we address. It's a little bit different, I think, than the typical hourly worker. I guess we can go on to the next question. I can just follow up on the rule question. Yeah.
Where is the updated form located in the website? I believe that Miriam can share this information on the chat, Safina. Okay, one more question here. How long is the employer required to retain records of distribution of notice of rights?
So the law requires employers to keep records generally for a period of 3 years. So 3 years. Let me just follow up on the question about commissions. So it's Rule 7/106, and it has when it's adding together the total earnings and then dividing it by the number of hours worked in the most recent work week where no sick time was taken.
Thank you. Emilia is asking, are my employees entitled to get cash out if they do not use the 40 hours?
If you use the front loading method, then yes. If you decide not to front load sick time, then they would have the right to carry over any unused sick time into the following calendar year.
Until when? The first quarter or longer than that?
Until they use the time. So they would have all their unused sick time from the previous year, and then they would just keep accruing. They would start their new 40 hours.
Thank you. Just give me 1 second. I'm going to look on the chat. If one is having a problem getting paid for family leave of absence, who will they contact?
For family leave of absence, is that the same as
FMLA.
paid?
I think they're talking about FMLA, and I put
FMLA,
in a link there to USDOL.
Oh, perfect. Thank you.
Because the United States Department of Labor enforces the Family Medical Leave Act. So I put in the link in the chat.
Right. And you may want to add also the link for the New York State paid family leave in case they were referring to that. Because my understanding is, well, there's been expanded FMLA related to COVID, but regular FMLA is still at the federal level is still unpaid, but they would be eligible for benefits in New York State.
Yes, and actually, Sandra just shared that FMLA is enforced by the U.S. Department of Labor, and the link is on the chat. Also, we are mentioning here, Median is mentioning that all the notice of employees' rights are available in English and Spanish. And they are working also on additional translation in 26 other languages. And the link to go to the Pay Safe Sick Leave information is on the chat. Just one more. I have more questions here. I just have to look at the. Employees start accruing as of day one. In the past, the law allowed that the employees could take 4 hours, not less. Do we have to give them 1 hour pay if they request it?
So the 4 hour increment only applies to the first 4 hours. So basically what that means is that if someone asks for time off in a day and it's less than 4 hours, the employer can deduct 4 hours. But if they say need 5 hours, the employer can't deduct 4 and 4, 8 hours. They would only be able to deduct the 5. So that 4 hour increment only applies to the first 4 hours. And that has not been changed. So if the employee needed, to take an hour or two, and the employer has a 4 hour increment policy, it's not a requirement, it's just an option. They can still enforce that. But again, and this has always been the case, the employer cannot have more than 4 hour increments in one day. So if the employee in one day needs more than 4 hours, then the employer can only deduct in 30 minutes increments after those first 4 hours. So if someone, let's say, needed 4.5 hours of sick time, the employer can't deduct 8 hours. They would only be able to deduct 4.5. It's a little confusing, but that provision basically has not changed.
Thank you. Pedro is asking if an employee has 60 hours accurate and they quit the job today. Do I have to pay them those hours on their last paycheck or they lose them?
So there is no requirement in the law that you have to pay anyone out for their sick time if they quit or if they get fired. However, if your policy that you have in place has that, then you do. So if you've already created a policy that you've given out to the workers and it says when you leave, you'll get paid out your sick time, you should follow your policy. But there's no such requirement in the law.
The same person is asking if the employee didn't use part of the 40 hours sick leave. For example, they only use 10 hours and roll over 30 hours. Is asking the employee leave the job, that what happens with those 30 hours?
They do not have to pay them out unless they have already in their policy said that they have a policy where they pay employees out. In the law, they are not required to pay it out.
If my employees, this is Emilia, if my employees work a total of 40 hours a week for 50 weeks, are they entitled to only 40 hours of paid leave and then the remaining hours unpaid, or do they have to be paid for all the hours accurate?
So you are capped at 40 hours, depending on the size of the employer. If it's 100 or more, then it's 56. But basically, once your employee reaches 40 hours, they don't have to. You don't need to pay them more hours than that. They don't need to accrue more. So it doesn't matter if they have, if they work longer, and theoretically at the rate of 1 hour per 30 hours a week, they might have had more hours. If you're not an employer that's required to provide more than 40 hours, then you fulfilled your obligation with the 40 hours. Again, I do want to emphasize though that these are the minimum requirements of the law. If you as an employer choose to offer a more generous policy where people just keep accruing past 40 hours, even if you have fewer than 100 employees, we strongly encourage it, but it's not a requirement.
And in general, what is the sense, how do you feel at this moment with the COVID-19 situation? It's just a general question about working under these new circumstances.
Sure. So, personally, not great. No. So when the pandemic first hit in March, we were flooded with cases and questions. There was a provision. I actually didn't get a chance to get into it, but I'll do it now. And there is a provision in our law where if the employer's place of business is closed due to an order from a public official related to a public health emergency, so for example, the executive orders that Cuomo issued shutting down workplaces, the worker does have the right to, assuming that you haven't fired the worker, the worker does have the right to use their sick time, any accrued sick time, to cover that closure. So, let's say you're closed for a couple days because you're in, one of these like orange zones, but you haven't, the worker's still technically employed by you. The worker can use their sick time to cover those closures. And those were provisions that were in our law from the beginning. We had never used them until the pandemic hit. So in March, we got tons and tons of calls from workers, just everyone, trying to figure out what their rights are. We were trying to get up to speed ourselves, both on this rarely used provision of our law, but also the new laws that we're passing at the state level and also the federal level. Then a few months in, we set up a worker protection hotline. So it's still actually in place, although the number of calls have really dropped, but that is still a resource that's available. Basically, you can call 311, ask for worker protection. And if you have specifically like a COVID related question, we have staff that can answer it. And that was in part related to reopening. And so there was a lot of questions coming from workers, very concerned when New York City started reopening in terms of what their rights were. And, what if the employer wasn't, conducting the reopening in a safe manner? What if they weren't making people wear masks? If they, didn't have hand sanitizer, like what could they do? The answer is, if that's happening in your workplace, call 311, ask for worker protection. We can send inspectors. Those laws are all still in place. And so, right now we haven't seen the same surge of calls that we saw in March and during reopening. That isn't to say that it's not going to happen, particularly if there is a citywide shutdown. But what I will say is that we are a lot more prepared in many ways than we were then. Like we're pretty familiar now with all these different provisions and protections for workers. We have a team in place that can answer questions. So in that sense, we're a little bit better placed than we were earlier in terms of, what's going to happen with the city. It's impossible to know. Hopefully, the vaccine will get out there before things get really bad.
Thank you. There are two questions on the chat, and they are related to union chat. One is, we are a union shop, and so we have only 4 full-time office employees, management, and all the other employees are sent by the union as we need them. In a calendar year, I may have 150 employees on my yearly payroll, but only 4 employees full-time. Am I considered a less than 5 or more than 100 employer?
So it's something that we would have to look at, your specific payroll. So the question can vary. There's what's called a fluctuating employer, and we would look at like previous quarters and how many employees were there. Part-time employees do count as employees, not just full-time employees. And one thing I actually didn't emphasize, but now is a good opportunity to do so, is that part-time employees are also covered under our law. They accrue at the same rate, 1 hour per 30 hours worked. It's just that since they work fewer hours, they accrue more slowly their time. But yeah, so part-time employees do count as employees. In terms of whether, how many employees you have at a particular time, it kind of depends on, for example, if we get a complaint and what what the time period was in which someone said they should have been paid sick time and they weren't, and how many workers were on at that particular moment in time, and then also looking back at previous calendar quarters to determine what the employer's obligations were during that time. That said, if there is a valid collective bargaining agreement in place and the agreement both expressly waives our law, it basically says this agreement waives the sick leave law and provides comparable benefits to what our law provides. It may be that the collective bargaining agreement already provides the workers what they need, and we wouldn't get involved anyway. But those two requirements have to be in place. They have to have expressly waived our law and provide comparable benefits.
Thank you. And it's important to mention that this law applies to union and non-union employees, right?
That's correct. The only way that it won't apply to a union workforce is if those two requirements are met, that they have comparable benefits and that they've expressly waived our law. And if a worker or even an employer has a question as to whether the benefits are comparable, that is an analysis that we provide. We can look at the collective bargaining agreement and just see whether the benefits are comparable or not, and whether that should be plain language, whether they've expressly waived the sick leave law or not.
Frank is asking if they can write into our company policy that sick time not used during a calendar year will be paid out on any specific time, let's say out on the first payroll the following year.
So that's fine, provided that the person has access to the 40 or 56 hours immediately after that. So an example would be, if you don't use the sick time by, let's say, December 31st, it gets paid out. But then on January 1st, that person has to have access to 40 or 56 hours available to them front loaded. So that just has to be very clear, because what unfortunately does happen is where an employer might pay out the sick time, but then starting the following calendar year, then the worker starts back with a sick leave balance of 0. And that's a problem, because, they had all this time accrued and maybe they got sick in January. Now they can't use any time off because they don't have any. So that's why if you roll over, if you have a carryover policy, let your employers know if you do pay out any unused sick time, which is totally fine, again, as long as you let the employees know that this is how it works, then as soon as you pay out that sick time, the employees should get access to 40 hours immediately, so that if they are, if they do have a medical issue, that they have access to that time.
Thank you. What about the enforcement considerations? There is a question about are enforcement considerations being made to ensure businesses are overly burdened during these difficult times?
Definitely. And as I mentioned, with these changes in the law, we do look at whether the employer was, in good faith trying to comply, whether, to what extent were they aware of the changes in the law. We also do take into consideration whether it's a small business, financial hardship. If someone says they just don't have money to pay these fines, we will look at their, if they have financial documents that we can review just to, make sure that they're not just telling us that, but that it's actually true. That is something that we take into consideration in terms of, civil penalties or that kind of thing. Our number one priority is always the workers and just making sure that the workers are whole. We're not out there to punish employers or, to be punitive. We want everyone to know what their rights and obligations are, and for workers to be in a place where they're getting the benefits that the law allows. But we know we're not like trying to put people out of business or anything like that. So we will work with, if we do get a complaint against a particular employer, we will work with them. And if they do have a situation where they're in a financial hardship, that is something that we do take into consideration.
What suggestions do you have for employers to ensure they are in compliance?
So what I would recommend is going through our website and particularly, looking through all our materials, the Notice of Employee Rights. We do have as I mentioned, our frequently asked questions. That's probably one of the best places to look, because it has a bunch of different scenarios. If worker comes and says this, what does the employer have to do? And I think it's written in plain English. It's not, the law. I think if you read the law, it's very legal jargon, can be a little bit confusing, but the FAQs are intended to be provided in language that anyone can easily understand. And so that would be my recommendation, is to look through our website, you know, print out the notice of employee rights, which you should be doing anyway, read it. There's other tools for employers there as well. I think there's presentations, there's spreadsheets that they can use to track worker sick time. But then the FAQs may be the best one. It's long, but it'll be worthwhile.
Right. There is one more question here on the chat. It's from Ursula. What do you mean by pay out unused sick time? Means salary?
So a person should be getting paid their sick time at the rate that they were getting paid. So, and that should be at least the minimum wage. But if they're making a higher rate than the minimum wage, let's say they're making $20 an hour, any sick time that they use should be paid at that same rate. Payout just means that if the person didn't use the sick time, they get paid the equivalent. Let's say they had 40 hours accrued, they used 10 hours, they had 30 hours that they didn't use. The employer pays them the 30 hours that they didn't use at the end of the year. That payment should be at the same rate as their regular rate of pay, whatever that rate of pay is. And that's something that it was in the old law, but it's been further clarified in the new law to cover things like prevailing wage. So it's not just that you get paid out at the minimum wage, but you should be getting paid out at the same rate that you were making. And if that rate is higher, such as prevailing wage, it should be at that rate. And if the employer was, you know, paying the worker less than the minimum wage, which unfortunately does happen, we would seek that they be paid, you know, that would be a separate wage and hour claim with the Department of Labor, but their sick leave should be getting paid at the legal minimum wage, not a lower amount.
Perfect. Sandra, any comments? This is a class. This has been a full class for our members and friends and followers and participants.
Yeah, I just want to thank you again for bringing everyone together for these. It's so important. We know how much is changing, especially this year, and it's a lot for employers to keep track of. So we really appreciate this opportunity to share that information, share the resources that we have. It's hard because, you know, we try to create resources that are helpful, but it's not one size fits all. You know, different employers are going to have different needs. But just to reiterate a couple of the things that Claudia mentioned, you know, again, the clarity of the policies, clear communication with employees, updating them as things change, letting them know how much time they have left. Also reiterating, as she said, that these are minimums that the law provides. And so we appreciate that many employers have been more generous in this time with their sick time. And we really appreciate that. I think that helps everyone. It helps keep the infection rates down. It helps employees feel valued and be able to continue in their work path. And it helps I think everyone see that these are really high road employers, really trying to do the right thing, really trying to protect their workers. And so it's really a huge effort, and we really appreciate all that. So just wanted to reiterate that and applaud those employers that are going above and beyond the minimum requirements of the law.
Yes. It has been a yes.
Oh, no, I just wanted to say thank you. I think this is really helpful. I'm, you know, glad that we got this opportunity. Just one thing that I really, before we log off, wanted to add, you know, everything that we talked about is regular New York City sick leave. If the employee tests positive for COVID or has COVID related issues, I do encourage you to contact the New York State Department of Labor or the U.S. Department of Labor, because there are separate sick leave law and benefits that apply to people who have COVID. And so just wanted to make that clear.
Thank you. And I want to mention to all the participants that you can follow up us the recording on the Queen's Chamber YouTube channel and also on our website, and follow please all the links that Mildred shared and Miriam shared today on the chat. We don't have any other questions at this moment, but I want to take this opportunity to thank you all for being here, for sharing your knowledge and the importance of this new changes on the law. It's a protection to employees and employers also. Before we go, I would like to mention that at the Queen's Chamber, we also are in constant contact with city programs, and I'm going to share a special program that we run that called Chamber on the Go, that the participants can fill this survey and I can follow up with you guys um, during later on for any needs that you have, and we can support and connect you with resources that is provided by New York City government and also by SBS. I just shared the link on the chat about the Chamber on the Go program and the English and Spanish form. I would like to wrap up, and Sandra, I invite you to close the program.
Okay, thank you, everybody. Thank you again to Thomas Gretsch and to Jacqueline Donato at the Queen's Chamber, bringing these great resources to the businesses in the community. And we're welcome any questions that you have, and please feel free to reach out through 311 and again, our website. And thank you all, and stay safe.
Stay safe and happy holidays.
Thank you.